A lot of us that serve on the board recognize that our time advancing these principles exists because of giants that came before us. And unfortunately, we lost one of those earlier this year and this summer. And I just want to say a few remarks about him in memoriam of Ralph Langer. Ralph was the former longtime president of the Freedom of Information Foundation and really a guiding light in transforming the foundation into the leading voice it is today here in Texas in the area of open government and the area of the First Amendment. Ralph passed away in August, a few weeks ago, in his home in Rockwall after an illness, and he was 84. And I just want to share a few things that just reflect in the magnitude of achievement and impact that he had on the work that we do at the FOI Foundation. He retired in the late 1990s as the editor of the Dallas Morning News, and he guided the news to 5 Pulitzer Prizes during his tenure. In 1992, the newspaper won the prize for investigative reporting for a series that exposed the use of excessive and often deadly force by Texas law enforcement. Much of the information and data for the series came from open records requests to police departments and sheriff's offices. And as part of that series, Langer approved the filing of lawsuits by the Dallas Morning News to enforce the right and the promise of public information under the Texas Public Information Act. Robert Deckard, who's a chairman and CEO of BLO Corp. And the parent of the News, tasked Ralph in the mid-1980s with making something out of the FOI Foundation. Deckard had helped establish the organization in the late 1970s in the wake of the Public Information Act hitting the books in Texas. And for its first several years, the FOI Foundation had been little more than an idea as an informal sort of adjunct to the Dallas Press Club. But not for long. That soon changed with Ralph in charge. With the encouragement of Deckard, Langer secured a seed grant of $150,000 from BLO that allowed the FOI Foundation to hire a full-time paid staff and house itself in a permanent office for the first time, complete with working telephones and fax machines. Now, Ralph hired Nancy Monson, whose memory we recognize with our luncheon each year, as the executive director. And the two formed a really strong partnership that led the foundation in those early days, created the structure, the programs, the goals that we carry forward today. Ralph secured editors from the state's largest daily newspapers to join the foundation's board, and many of the lawyers that were fighting First Amendment cases and other battles for those newspapers to also join the board, to combine their expertise in preserving, again, the promise of public information and open meetings. And transparency. Ralph shepherded the FOI Foundation's first annual conferences into existence. He attracted keynote speakers to the foundation from among the most prominent state and national journalists, thought leaders as well. And by showing the way, Ralph demonstrated that it became obligatory for leaders of the Texas legislature to also join us and pay heed to the foundation on every bill that affected open government. Finally, Ralph also led the foundation in offering open government seminars to the public, to journalists, and to government employees who are tasked with ensuring that when we send an open records request, that it's properly processed, and the result is that we get public information. Among his survivors are Ralph's wife of 61 years, Kathy Langer, who dedicated countless hours to the foundation as well. And so we'll just take a brief moment's silence in honor of Ralph. I know Ralph will be proud that we continue the tradition today at the foundation to host robust discussions about the need for transparency, public information, open meetings. And in the spirit of that, I want to remind everyone that the FOIFT is a 501c3 nonprofit. We don't endorse or take any positions on political campaigns or issues or races. We like to hear from all the AG candidates. We invited all of the GOP candidates today because we recognize, as many of you do, that the Attorney General's office plays an important role under the Texas Public Information Act and its role as the decider of whether government is able to invoke the exceptions and not produce public information when it claims that it can prevent itself from, it can avoid doing so. And in that light, we like to hear from the AG candidates. And so we're thrilled to have Land Commissioner George Prescott Bush join us today. He's a native Texan, and he was first elected to the Texas Land Office as Land Commissioner in 2014 and overwhelmingly reelected in 2018. He's a Republican candidate for Attorney General, and in his capacity heading up the General Land Office, he works on a host of issues. Led the state's housing recovery post-Harvey, oversees billions of dollars of investment that the state makes in education, and also oversees the oil and gas production on state lands, in addition to protecting private property when necessary, when the federal government, for example, impedes on property rights. And this is the Red River ranchers and farmers dispute that he was leading the charge against, along with other allies. Finally, he also oversaw the preserving of the Alamo. Our keynote interviewer, many of you will recognize Bob Garrett. He is the Austin bureau chief for the Dallas Morning News. He has covered state government and politics at the News since 2002. And some of you may not know that he was a State House reporter for 3 newspapers, including the Dallas Times-Herald. He's a 5th-generation Texan and got his degree at Harvard. I know that Commissioner Bush got his law degree just down the street here at the Texas Law School, so tip of the hat to that for the lawyers in the room that are Longhorns. And without further ado, I'll hand it over to Mr. Garrett and look forward to a nice, robust discussion. Take it away.
Nearly 4 years ago, Senator Jane Nelson hauled you before the Senate Finance Committee. I don't know if you have scar tissue from this one, but it was talking about the Alamo Trust. And for those of you who don't know, the Alamo Trust is a subsidiary of the Alamo Endowment, and it's a nonprofit that, unless something's changed since December 2017, held closed board meetings and wasn't subject to the Texas Public Information Act. At the time, senators said you should do voluntarily more to make public some information about this big public-private project involving the Alamo. Quote, "Keep it transparent. My folks want to understand what's happening here," Senator Joan Huffman, Republican of Houston, told you. Now you're running to be the state's most powerful official on open records. Do you feel like private actors performing government functions should be subject to the TPIA?
Thank you, Bob, for the question. Thank you for having me. I want to thank the foundation for welcoming me. I'll also reiterate I'm the only candidate actually willing to spend the time with you, because I think it's important. When you look at the AG's office, 4,200 employees, 1,100 are devoted to this issue. So I think any serious candidate for this office needs to not only be here, but build that relationship with the foundation. So Kelly, thank you for having me. You're right. The Alamo, when I came into office, was totally ignored. It was literally falling apart. And when I came into my first legislative session in 2015, I focused on getting money to the Alamo. We went out and cast a very wide net to bring in a third-party manager. And lo and behold, nobody stepped forward to manage the day-to-day operations of the Alamo. We finally closed a deal in 2016. You may remember the controversy with the Daughters of the Republic of Texas. We decided to go in a different direction. And the new group that we brought in was basically a committee of philanthropists in San Antonio, Houston, North Texas, from around the state. And so in that legislative session, not only Jane Nelson, but Kirk Watson, the former state senator, recommended that we as an agency subject the agency not only to the Public Information Act, but to the Texas Open Records, or Texas Open Meeting Act as well. So back in 2018, we went ahead and did that, and then in 2019, we codified the Public Information Act aspect. I kind of view this in 2 prongs. But we went ahead and subjected ourselves to the Texas Open Meeting Act. So you can watch and this is the Alamo Trust Incorporated, also known as ATI, that run the meetings quarterly. All the documents, all the emails, the texts, they're all subject to public scrutiny. And this is, I think, important because as an executive head, I have that experience with the legislature to have that conversation. I want that conversation with you, members of the foundation and the board, to say whether it's ERCOT, whether it's Alamo, that we need to open the books. And so when you look at the winter storm, I think the current Attorney General was wrong in taking the interpretation that all of the correspondence, all of the emails, all the calls weren't disclosable. And I think he was wrong. And I still think it's disgraceful. He hasn't disclosed anything for his luxury ski trip in Utah while you and I were freezing our ass off during that storm. What does he have to hide? The Utah Attorney General disclosed more documents than him. So, look, I think and we'll have time to talk about this, but I have a lot of different ideas by which we can make government more transparent. But to answer your question, I think the court has weighed in at the highest level to say that if there is a substantial amount of taxpayer funds that go to an entity, even if it is considered a nonprofit, should be considered a full-blown governmental entity for purpose of the Public Information Act.
Well, you anticipated a couple of my questions there, but in March, nearly every major news outlet in Texas came together to publish a story about General Paxton's use or abuse of the Public Information Act. Specifically, he's refusing to release any communications regarding his trip to D.C. on January 6th for the January 6th rally, and some of the other trips you mentioned, the one to Utah. So you're emphatic that as Attorney General, you would release even your texts and emails wholesale, because he's wholesale rejecting release of them.
Well, I think it's critical that there be a mechanism created where the AG is removed from the process as it relates to request of the AG's office, if that makes sense. And I would be for a wholesale firewalling process, because let's talk about one of the other incidents involving Ken Paxton, and that's the only time he went down to the Legal Services Division was to intervene to write a legal opinion on behalf of Nate Paul, his financial donor that hired his mistress. You got to remove the official, and that's what I've done at the land office with respect to contracts that are requested from our agency, is to remove myself entirely from that decision-making process. So I think there's other ways in which we can work with the legislature to expedite the process for when those requests come in. Right now it's at 45 days. Why can't we, with modern day technology, look at 30 days? Why can't we look at, I know there was a bill filed to this extent, but to increase the penalties by which people refuse to release information, and actually put teeth in the law to say that the Attorney General's office can either mediate, as is the case in Florida or Georgia, or have that original right to prosecute cases or governmental entities that refuse to release the information.
A few years back, the state began redacting elected officials' home addresses from otherwise public documents, including the personal financial statements filed annually with the Ethics Commission. That's made a reporter's job harder in tracking, just like simply whether legislators actually live in the districts they represent. Would you support going back and taking that law back so that, and I know this could be a subject close to home for you from a few years ago, but I mean, would you support repealing that law?
I'd have to take a look at the proposed language. I just can tell you that in the Alamo discussion, I know it draws laughs usually, but we did have threats. It was a very contentious discussion, and as elected officials and as a young family with 2 kids who are 8 and 6, I worry about their security. I know in Travis County, for example, as a military veteran, I would qualify for that redaction. Maybe there's a way in which, we can look at, for example, the lender that lends to the home, or other ways to bring transparency to the process without disclosing. To be honest with you, as an elected official, we live in a world of doxing, where sometimes once somebody gets a hold of your address, you can be you can be assaulted. So there's a balance. I'm open to that discussion and willing to visit with the author. And that's what I want to explain to each and every one of you as well, is during the legislative process, I'm open to visiting with legislators on issues of the Information Act, because I think it's sensible for open government. So there's ways in which we can get that information out, but not risk the personal safety of those who hold office.
In the last regular legislative session, which seems like an eternity ago, but it was just this year, the current Attorney General proposed a bill that would flip the Open Records Act on its head. It would have allowed governmental entities to redact information they felt they should in the very first instance, and then put the burden on the requester to seek an AG opinion to overturn those redactions. And we've seen numerous examples of where this led to agencies just wholesale redacting documents for reasons like, quote, because it would be embarrassing, unquote, to release. If you're elected, would you ever propose a law like General Paxton did, like that?
No, I think it's trying to hit the easy button. I think this shows a lack of management of what's happening under this law. Basically, the requests have tripled in the last 4 years in terms of requests to governmental entities. And so, since this is a statutory charge of the AG's office, as a manager, I would reinvest resources from other areas of the agency or ask for supplemental support from the legislature to meet those needs by hiring more folks, whether that's full-time employees and or attorneys, to review the opinions and to expedite the process and meet the speed of business, because the speed of government is not keeping pace, and the speed of this particular area within the AG's office is not meeting the needs of what the public's right is to know on issues. So he hasn't raised the budget. He hasn't raised any FTEs in this area of the agency. And because of the broken relationship that he has with the legislature, for anybody who followed his scorecard, so to speak, from the LBB, you'll see that they'll never trust him again. So we need a new Attorney General that can rebuild that trust, invest the necessary resources so that we can expedite the request quicker for news agencies and for the broader public.
Well, I'm not going to get into the Google antitrust case, but you've raised a question of sort of a horse and buggy, antiquated approach, not having the personnel and not using electronic means. You're, I'm sure, well aware of the current Attorney General's policy concerning skeleton crew and how during the COVID pandemic it's been abused. So basically, that allows agencies to just indefinitely not follow those deadlines for responding, and that's delayed journalists and the public from getting records they're entitled to receive. So do you think we have the technology to allow remotely working employees to gather and fulfill open records requests?
Absolutely. We are an agency. We have 800 full-time employees, and we transitioned within a month. And so, I believe that the law was, or this component, or the legal opinion was based upon the assumption that we would only have tornadoes, hurricanes as natural disasters in Texas. Didn't contemplate pandemic. And I think a lot of us would agree perhaps a grace period of a week, and I think that was a proposal from the ledge to give agencies to toll the clock, so to speak, before the clock starts again on getting documents out. But we moved and we continue to operate remotely. So I disagree with the AG's legal opinion there. I think it's been abused by other state agencies. Our agency, just to be totally transparent, for about 4 months did the same thing, until I found out about it in a staff meeting, and I said, I don't care what the AG's legal opinion is on this issue, it's not the right thing to do. The public deserves the right to know when they're asking about elderly care facilities, namely the 8 that we manage for military veterans. And so it was El Paso and I think the Chronicle that were reporting on that, and we reached out and provided those documents. And now in real time, we're providing up-to-date information on elderly care facilities that we manage. And Senator Zaffirini passed a bill that I think is the right thing to do to not violate HIPAA. Let's preserve the privacy information of those in their healthcare documents, but in terms of the locations and the amount of cases, that should be known to the public and to community members that have family members in these facilities. So I call upon other agencies to ignore this rule. As AG, I would work with the legislator to codify that, to define, for purposes of the Public Information Act, days to not include Saturday, Sunday, and state holidays. And I think we can put this behind us.
That's good, because that, one of the few bills that, transparency bills that passed did allow catastrophe notices, which kind of takes care of the problem from the agency side. Well, you mentioned Winter Storm Uri. Your thoughts are that the PUC should have had to disclose everything?
Absolutely. Yeah, I like, and I'll have to get the citation to the court case, and when it was in connection to another nonprofit, the Greater Houston Partnership, which some of you from Houston may be familiar with, which does receive substantial funding both from federal government and state government. And they took a position in court that they weren't required to disclose some of their internal deliberations. And so that was brought to the court. The court ruled that using a substantial interest test, that if a public entity is funding, that there should be a requirement. So I think ERCOT clearly, they took the defense along with AG Paxton in his legal opinion that since the PUC is essentially has oversight over ERCOT, and that ERCOT is a nonprofit entity, that they're not required to disclose. But if there's an incident from this past year that concerns Texans when I visit throughout the state, it's the state's response to this. And the only way to get to that is to understand what went wrong. And so I think considering the legislature really didn't move the ball a lot on the issue, this may have something to do with it because they weren't required to disclose internal emails, texts, and other documents. And so I would be for that litmus test in terms of evaluating.
In the interest of time, I was going to give you a parade of horribles from a reporter at the San Antonio Express News, Joshua Fechter, who's now moved to the Texas Tribune, but I'll spare the audience that. But a shocking degree of just flat-out non-response to open records requests from all levels of government, local and state. I believe you said earlier that you would support some kind of penalties. And there have been bills about that. Now, when we say penalties, we're not necessarily putting these people in jail. That's things like training. But I mean, you're definitely supporting that. We can get you on record on that.
Yeah, so I believe the statute does allow for a fine of up to $5,000 and half a year in jail. Perhaps you revisit that and put some teeth behind that in addition to just training. Because that's the only way that people are going to get serious about it is to put additional liability.
Let me ask you an education-related question. Are you aware that under the Open Records Act, charter schools are treated differently from public schools at school districts? Oftentimes, charter schools are not subject to the act, increasing concerns that sweetheart deals may be going on there undetected. Would you take a look at that?
I would take a look at it. I'm a big advocate for public charters, and one of the reasons why is, we're for an equal playing field and being evaluated based upon the same criteria, and that standard should apply to information. So I haven't followed that, honestly, the issue as detailed as I should, but I'd love to visit with the foundation and maybe have a roundtable with the charter school movement.
One of the growing problems is redactions of birth dates from public records. In 2015, there was a regional state court of appeals ruling that is leading to thousands of redactions of birth dates. Practice is not uniform statewide, and we would, in the news industry, we use birth dates for simple things like vetting candidates, but also making sure we're naming the correct person in stories, but it's not just a special interest concern of news media. Many industries need these to properly vet prospective job applicants. And do you support continued access by the public to the DOBs and these kinds of public records?
Again, that's another issue I'm not as briefed on, to be honest with you, and I'd feel I don't want to commit to a position right now. I am mindful of fraud, and that is another charge of the agencies, making sure that we're protecting people's information as well. So cybersecurity being one of them on behalf of the state. So I don't want to commit to a position at this time.
Let's talk about law enforcement a little bit. The police records, such as narratives, videos, and other documents, are withheld when a charge doesn't result in a conviction or deferred adjudication. But this has led to a perverse interpretation about such documents, videos, involving defendants who have died. And there was a high-profile case, the Graham Dyer case, of in the Mesquite jail. He was tased. He had various issues and was substance abusing the night of his arrest. But his mother was unable to get through the Texas Public Information Act records that she used the Freedom of Information Act, the federal act, and got the videos that showed abusive police abuse while he was in custody preceding his death. And should we continue to let police departments hide records when someone dies in their custody?
Well, this is a tough case, one that was big news in the Metroplex, and I can't really take a side in this one because as the parent of two boys, again, I can't, as a parent, imagine a situation like Mr. Dwyer encountered. I do think law enforcement have the right to basically adjudicate their personnel decisions internally, and the public should be, I think, shielded from that process while they determine discipline, while they determine whether or not to terminate, and to keep that out of the public eye, because we live in a society now where the inflammatory aspect of showing video it's prejudicing juries, it's making law enforcement jobs more challenging. I do support the right to know, and in this case there was the federal right that allowed them through their civil rights case to get the additional information. I know Representative Moody filed the bill and would like to visit with him on the details of instances where maybe there's a closed audience or a closed viewing of a family member. Like, for example, in the situations we dealt with elderly care facilities, the media would sometimes criticize us for not releasing HIPAA-covered healthcare information to relatives, but we would remind them that only folks with a statutory power of attorney or a direct relative, one step above and one step below, we could show information to. So there's ways to work together to try to meet the end game without jeopardizing a consequential result that could really inflame a really difficult situation.
I have a few politics questions, but I wanted to open up to the audience any questions furthering this topic of transparency. I know Lauren, my colleague Lauren McGahee, may have a question, and I can.
I like the mask.
Isn't that a good one? I can just give you the microphone.
Thanks, sorry. I didn't mean to grab this from anyone else that has a question, but I have a very quick one. Do you think that the Attorney General himself should be subject to the Texas Whistleblower Act?
Totally. I think it's the most asinine legal argument I've seen in a long time, where in appeals court he claimed that as an elected official, we're not public officials because he's elected. And that totally defies the spirit of what the law is intended. It's intended to protect employees that suspect crimes being committed by their superiors. That's the whole purpose of the Whistleblower Act, not only at the state level, but the federal level. So he claims he's not subject to the suit that's being brought by 8 of his top lieutenants, and these weren't, career officials that have a grudge against him. These were his folks that he brought into the agency. So I don't suspect that. In fact, I think one of the reporters commented in the headline where that the appellate court was skeptical of the argument. I would be very skeptical myself. And it's just a shame. We shouldn't have a top lawyer, regardless of your viewpoints, in question and in doubt. And we need to protect those that witness crime and bring that to the public.
Commissioner, this is Laura Prather. She's on the board of the Freedom of Information Foundation, but she's also the libel attorney for the Dallas Morning News. So,
Thank you for being here, first of all. I wanted to follow up on your answer with regard to the in-custody death issue, and maybe just help you reframe your outlook on this, because I understand the need to have the family members have that closure, and certainly Kathy Dyer and others have testified in very compelling and gut-wrenching ways before the legislature about that need for closure. But the problem is that leaves out the public, and what we have is a problem of public accountability of law enforcement officials. And so if that investigation, if that internal investigation of law enforcement is completed, at that point in time, would you be in favor of not leaving the discretion with law enforcement and allowing the public to have the information so that they can have further trust in their law enforcement?
To the extent that there's a plaintiff out there that can demonstrate the right to know and can essentially have a due process right following the internal investigation. But again, I want to be able to examine the full picture of what's available to somebody, whether it's, say, the media corps, somebody in the community, to find that. And again, look at the federal options that are available to any citizen. So again, I don't want to commit to anything here. I want to dive into each case. I'll firewall myself from legal opinion drafting from staff, but I want my staff to investigate every single case and give it the credit and the diligence that it deserves, instead of just kind of rubber stamping opinions.
Thank you.
anyone else? Got one back here. I'll start with you, Mr. Bussian.
Commissioner, John Bussian here. Your wife, Amanda, is a lawyer who spent...
It's a cross-examination.
Kind of. You'll see where I'm going with this. Who spent a career advocating First Amendment rights and the right to know. Has her involvement in those issues impacted your view of the world?
I guess you put me on the spot here, John. My wife was an attorney at Jackson Walker for many years, represented news publications throughout not only Texas but the country. And yeah, I mean, it's interesting for her because now she's married to a public official. So my libel slander law is pretty weak, but if I recall correctly, there's a pretty wide gap there between elected officials and private citizens. No, she. Let me just put it this way: you all have an advocate in the Bush household. She built great relationships and argued many cases on these issues, and I think saved a lot of publications here a lot of money. No, she's just a great mom to our boys, and but also, you know, brings a different perspective on issues.
Hello? Oh, wow. Commissioner, what would you do to expand the investigative abilities of the Office of the Attorney General? Kind of a background. I filed public information requests to several legislative offices requesting information, call logs from them, and previously they had provided information, but then decided in future requests not to provide them. I received information from the Office of the Attorney General where they said they do not have the ability to go down and investigate when an office is refusing to release that information that they already have. What would you do to kind of expand that, your abilities?
Sure. So one of the statutory changes that we're proposing in this campaign is to look at Florida and Georgia, where their AG has a broader capability to not only investigate in areas of criminal law, but to follow on with respect to Information Act cases, because you're right, with what we have heard just over there is that they're not keeping pace with not only just information requests, but also requests for investigation and following through, including victims. We haven't talked about criminal victims, and we are kind of the clearinghouse for that as well. So there just needs to be a reexamination of how this is viewed as a customer service. That's how I try to run the land office with, and visiting with staff, is to run this really, you know, at the outset, as you all talked about, that we are not the boss, you are the boss, or at least the public is. And so reexamining how we can put the resources into that so that we can be more responsive,
Thank you, Commissioner.
especially on the legislature, anything involving the legislature.
We have time for one more, Kelly? Anybody over here? Come on, David, you have a question. No? Okay. You got one?
Commissioner Bush, the AG's office for a long time, for many decades, has played a really central role under the statute. It's literally the clearinghouse to whether or not governmental entities can validly assert an exception and withhold documents. And in my view, one of the reasons that it is saddled with so much work and has to dedicate so many resources to it is that there's no other alternative for requesters to seek a ruling on their objection from the government and just get their records. Would you be in favor of looking at other means for requesters to seek enforcement of their requests versus only kind of relegating themselves to waiting on the bureaucratic processes and the AG issuing an opinion for literally every single objection that's invoked to a document request? So alternatives to enforcement outside of the AG's office.
We'd be interested in looking at any and all measures to make this more of an expedited process. You touched on one issue that I haven't addressed, and that's the exceptions. Because there are now 60 exceptions to not disclose under the Information Act. That probably needs to be re-examined as well. The current guy has used the attorney-client privilege for his own activities for just about any communication he's made. So kind of reining in not only the size and scope of that exemption, but having a different enforceability mechanism. And so, again, we've been talking with other AGs in other states, and again, adding more teeth to the process, providing an alternative other than just, say, the AGs, if we're not moving quickly enough for you. We'd be open to that discussion, and that's going to require work with the legislature to craft that too.
Thank you, and I'm going to turn this back over to Arif. Okay.
Thanks, man. Appreciate it.